The earliest Americans were motivated to fight for freedom because many of their basic rights had been violated. When the British king tried to remove jury trials in the colonies, early Americans saw yet another good reason to assert their independence. As a result, the right to trial by jury has long been regarded a cornerstone of the American system of justice.
We, the jury, finds as follows. As to count 1, we find the defendant not guilty. As to count 2, we find the defendant not guilty. So say we all this 11th day of December, 19...
If we're trying to pick a fair jury here.
I was shocked and stunned, disappointed and hurt, and I'm angry.
The founders thought jury trials were so essential to the newly formed government that they mentioned them in the Declaration of Independence, in the body of the Constitution, and again in the Bill of Rights. To ensure that jury trials would not be denied, the founders wrote the Sixth Amendment, which guarantees this fundamental right to all people accused of crime.
The jury serves exactly the same function today that it served 250 years ago. The criminal law is subject to abuse by those who are in power. The jury is the simplest and most democratic way to put a brake and to look over the shoulders of those who have power.
Juries are important historically because they were the one buffer that existed between the power of the state and the ordinary citizen. The ordinary citizen's life, liberty, and property would be decided in a criminal case. The judge works for the state. The only buffer you have is ordinary citizens, a jury of your peers, deciding whether the charges against you should result in conviction.
What difference does it make to us whether the jury is out 1 hour or 1 week or 1 month if the verdict is a bad one? And we feel that this verdict was a bad one.
I think that it's very difficult to stack the deck when you're dealing with a jury.
Do you ever want to be on a jury again? No.
Thank you very much.
While most people will never become a judge or hold elected office, there is one position vital to the self-government of the United States that most citizens are likely to hold at least once. All citizens can expect to be called to serve as a juror, sitting in judgment of another. Today, a lot of citizens view jury duty as a burden, even though many people, including women and blacks, fought through the courts and in the streets to win the right to serve.
The jury system only works if lots of different citizens serve on a jury. That's the only way we can have, a defendant can ever have a jury of his or her peers. And so everybody who's able to serve on juries ought to serve. For many, many years, unfortunately in this country and elsewhere, the right to jury service was not open to everybody. It was for the privileged classes. And so I really hate to see people take it for granted.
And certainly juries ought to reflect the ethnic makeup, the intellectual makeup, the socioeconomic makeup, all of the ideological makeup of the community. Unless they do, then somebody is going to feel that they've been treated unfair and that the process is unfair.
Guilty.
I have to conclude that they reached, as they did unanimously, the judgment that 2 men were guilty and 2 were not.
The jury has spoken, and we, as well as our client, respect its labors and enormously difficult decision.
We, the jury, in the above entitled action, find the defendant, Orenthal James Simpson, not guilty of the crime of murder.
In all federal trials and in 48 out of the 50 states, in order to convict someone of a crime, all members of a jury must agree, producing a unanimous verdict.
We don't want to lock up people that we're guessing about, and the unanimity requirement helps us be sure about what we're doing. And even with the unanimity requirement, we have seen time and time again that juries can be wrong.
The consequences of a criminal prosecution for the defendant are so important. His life is at stake, his liberty is at stake, his property is at stake, his freedom, that it really makes sense to require all the jurors to come together and agree, and that's a very high burden for the prosecution, but it should be high.
What we want is 12 fair, impartial jurors who are going to follow
where we are still in this country.
This jury of 12 people took a look at the evidence and they decided that he was responsible.
In spite of the judge's instructions, jurors have the power to bring in any verdict they wish. Jurors also have the power to decide that the law is wrong. When juries refuse to issue a guilty verdict, even when the evidence clearly points to guilt, they are often said to have engaged in jury nullification. But often juries are not told of their power to decide the cases before them based upon both the facts and the law. And so many people wonder if jury nullification is a good idea and whether juries should be informed of their multiple powers.
If jurors are told they get to do whatever they think is right, that can make it hard to convict people who maybe should be convicted. You also have to consider the possibility of racial discrimination, for example. Someone who sees a juror of a particular race and is hostile to that particular juror, not because of what he or she did or because of that person's character, but simply because of the color of their skin. And they might vote to convict based on that. Obviously, we don't want that to happen either. So there are pluses and minuses with jury nullification.
The notion of jury nullification is the exercise of the jury's power to say, I don't like this law, and therefore I'm not going to apply it. And this drives judges nuts. But those of us who believe in a free society and in the freedom of a jury to act believe that that is the appropriate message that should be sent.
The founders of this country put their lives and fortunes on the line in order to preserve the jury trial. And so the Sixth Amendment remains crucial to the American experience. When you serve on a jury, you embody what government of, by, and for the people is all about. I'm Tim O'Brien.